Timperio versus Bronx-Lebanon Hospital. Counsel.
Good afternoon, Your Honors, and may it please the Court, Sarah Rosenbluth, the Workers' Compensation Board. I'd like to reserve 2 minutes for rebuttal.
Yes.
The 2017 mass shooting at the Bronx-Lebanon Hospital was a horrific tragedy, but the horrific nature of the event does not change the fact that it was, at bottom, an episode of workplace violence. This court held in Rosen that under Section 21 of the Workers' Compensation Law, workers' injuries resulting from intentional assault presumptively.
So is it because the perpetrator was a former employee that connects it to the workplace?
That certainly strengthens our case, Your Honor, but it is
Would
not
it be different if it had been a random person?
It would not be different, no. And we see that in cases such as DeAngelis and Toro, where an unknown assailant, for example, in DeAngelis, threw a stone through the window of a painter's premises and injured him. And there was no evidence as to who this person was or what motivated him, but that's precisely why the presumption did apply and had not been rebutted.
In that respect, this case seems different from Rosen, right? Because in Rosen, I think there was some evidence that it was employment-related because they were coworkers, they were there at the same time, and there was actually, I think, some evidence of personal animosity, which the board didn't find credible. But here, as I take the record, there's no evidence at all with respect to the motivation. Is that right?
That's right.
Okay, and so why then, if this is a little bit different than Rosen in that regard, why does the presumption apply as you say it does, as opposed to, you know, there needing to be some evidence on one side of the coin or other? Or is that just how a presumption works?
The presumption is triggered when the injury occurs in the course of employment.
So that's all we need, in your view?
It is undisputed here that the injury, that Mr. Timperio was on the job when the shooting occurred.
And what is your understanding of our nexus requirement from our case law?
So the nexus requirement, our understanding is that it has no independent relevance in determining whether or not the presumption has been rebutted. It's sort of another way of saying, was the person on the job when the injury occurred? And
Well,
here,
Could I ask you, if this were a case where the perpetrator had just stuck a pin in a map and randomly selected this place, not having had a past employment relationship, would that create a sufficient amount of randomness to deprive you of a nexus to the accident?
no, because again, the inquiry in looking at whether the presumption has been rebutted is not whether there's a nexus to employment. It's whether the person was on the job when the injury occurred.
Well, I'm not necessarily talking about a nexus to employment. I'm just talking about some nexus, some connection between the actor and, the result that occurred. And I'm wondering if the person really they didn't know each other and the person had no particularized intent with respect to who or where or when they went to go commit this act, whether that sort of removes any argument that there's a nexus.
No, I think that would still mean that the presumption applied and had not been rebutted, because the purpose of only looking for evidence of personal animosity and rebutting the presumption is looking for some suggestion that the incident still would have happened outside of the workplace.
So September 11th attacks, workers' comp for everybody.
Correct.
So let me ask you about the genesis of the workers' comp laws going back, a little more than a century. Part of the motivation there, as I understand it, let me know if you agree or not, was to incentivize employers to remove unsafe working conditions like meat grinders that chop people's arms off, that sort of thing. Is that fair?
I think so, yeah.
So that policy concern doesn't really apply here. Would you agree?
That precise policy concern does not apply here, but there's a broader policy concern of just ensuring easy access to benefits for workers injured on the job through no fault of their own.
That's another motivation the legislature had way back, I think, right?
Correct.
So one is missing and the other still remains, is your view?
I'm sorry. Yes, I think that's right.
Okay.
Yes. And so the reason, as I started to suggest to Judge Pantero, the rule regarding personal animosity makes sense because when a personally motivated assault
is carried out in the workplace, it's likely to be pure happenstance that it happened when the victim happened to be at work.
So then, in a mass shooting, it is that the shooter wants to come in and shoot whoever is in this particular space? That's what matters, that they're just,
I mean,
they
that-
came in this example, came into the hospital, they just want to shoot someone, anyone, they want to assault people in the hospital. That's what matters, as
That's-
opposed to if they found them 3 blocks away, off hospital property.
That's exactly right, because it is the workplace that did in fact expose the worker to the risk here at Timperio. to the-
But for the fact that they were on the job at that workplace, they would not have been subject to the mass shooting.
Essentially, yes, and here there's no basis in the record to conclude that Timperio would have still been shot by Bello had he been elsewhere. We see this arising in cases of domestic violence, for example, where there's a long simmering domestic dispute between husband and wife that unfortunately turns deadly. Now, unfortunately, it is the case that the husband is out to get the wife for whatever reason and happens to track her down at her place of employment and injures or possibly kills her.
What about a natural disaster? Same result as 9/11? If you're on the job, then you are presumptively eligible?
I think likely, yes. That specific case hasn't really been tested in the case law, and that's not an assault. It's a little
Right, I
bit
understand.
different.
But why would that be any different under your reading of the statute than an intentional act, whether it's an assault or an explosion or whatever it might be?
So I think in a scenario where there is a natural disaster, a nuclear weapon that flattens an entire city that affects.
A hurricane, whatever.
Sure. It's possible that the rule would apply differently in that case. We don't exactly have a position on that scenario. However, I do think in general, the legislative policy judgment here is that in cases of doubt, essentially, the tie goes to the
I'm just
worker.
asking because it seems to me that your position, as I take it, correct me if I'm misunderstanding you, is that if you're in the course of, which I think means you are in fact at work working, then there is a presumption that it arises out of unless there is some evidence to the contrary, for example, personal animosity. So I'm not sure I see any natural cabining point on that continuum. And I
think
take it
that's-
it's not raised here. But
It's not raised here, and I think a natural disaster raises slightly different considerations, but I think likely it would be treated in the same way, that the presumption would apply and would not be rebutted, because
Well,
again.
it is possible, depending on the nature of the natural disaster, that even if you were 5 blocks away, you would have been subject to possible injury, if not a fatality, in the natural disaster.
I see my time has expired. May I
Please go ahead.
respond? Yes, and I mean, certainly, workers would, assuming there would be a remedy for workers in that scenario, it would extend only to workers. That is the nature of the workers' compensation system. It's not a general citizen's compensation system.
But
So-
I'm just analogizing it to your example about the domestic incident, right? But that is just, as you say, the attacker is hell-bent on either fatality or injury, and so they go all the way to someone's workplace and indeed attack them there, right? That's sort of that is, and if they caught them outside of the workplace, they would have attacked them there. So to the extent that you have a natural disaster, an incident that affects the space outside of the workplace, and someone is injured there, you're saying, well, that, I would assume you would think maybe that presents a different scenario.
I think in the event that a natural disaster
Yes.
or a nuclear bomb type of situation affected everyone
Well, that's
equally.
intentional, right? Not a natural disaster, but yeah.
I'm sorry?
The nuclear bomb's intentional, it's not a
Correct.
natural disaster.
Right, I mean, yes, that's
Yes,
different. But
yes.
in those scenarios, the salient fact being that they, in the hypo, affect everyone equally, there could be an argument in that case that work was not the but-for cause, and that could potentially provide a basis.
Being at the workplace, being
Correct.
present at the
Correct.
workplace.
Yes, that's what I mean.
Right, because you're not limiting it, it matters not, I think, in your view, whether or not, let's say it's me, I got to work early, my shift had not started, but I happened to be at the workplace, or it was my day off and I passed by for whatever reason. All that matters is that I'm at a workplace where I am employed.
Well,
Or does it matter?
If you're on your day off, there would be a question about whether you were acting in the course of your employment at the
Okay.
time, and so that would be a separate issue. But assuming you are in the course of your employment, yes, the presumption is triggered and can really only be rebutted under this court's case law by substantial evidence of purely personal animosity towards the victim.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court, I'm Karen Lilling on behalf of defendants, appellants, Bronx-Lebanon Hospital, and the State Insurance Fund. In furtherance to this Court's questioning about the rebuttable presumption, I think the question in the context of assault is what analytical framework should be used to make that determination as a matter of law.
I just follow
And
up on something she ended with. Does it matter from your viewpoint whether or not, let's just take the shooter in this example, the shooter is intending to shoot employees or just anyone who happens to be at the hospital on a particular floor at that point in time? So does it have to
I
be
underst-
directed?
I understand and I appreciate your question. And I think there is I think what you're asking is a very good question. I think the case law bears out it's a different analytical analysis when it's a co-employee versus a random stranger.
So
And
you think that there might not be compensation if he had not worked there previously?
No. That's not what I'm suggesting.
Okay,
What
so
I-
how are they distinct then?
Okay, what I'm suggesting is that there is a long line of cases that when it's a random assault, when it's, an attack by a stranger, dating back to this court's decision in 1929 in the Thomas case. If you look at the evolution of the case law, the outcome is almost always the same when it's a random attacker, and the claim is covered by the exclusive benefit because there is and can be no evidence of personal animosity toward the victim, toward the decedent, toward the one that was injured. There are limited exception, and those two cases that I found are Balaska and Wadsworth. And in those cases, the difference is that the claimant started the scuffle. The claimant was the one who approached the attacker. There was evidence of personal animosity, even though it was someone they didn't know. But in every other case, Thomas, Christensen, Moran, this court's decision in Toro, Valenti, Conyers, Rothenberg, Bennett, Boston, all of these cases involved an unknown assailant. And in all of these cases, there was an exclusive protection by the workers' comp law.
But not
Now-
Malakarn, right?
I'm sorry, Your Honor?
Not Malakarn, not the parking attendant case?
The parking attendant case, if you give me 1 second, Your Honor, I don't know, and forgive me if I have that in my list, and I apologize for not having the facts at hand.
I think it's in the papers. I think it's cited by the
The
parties.
parking attendant case might be, and I might be incorrect, Your Honor, I apologize, that had more to do with, I mean, if that was an assault by a stranger, then it would be,
Robbery by a stranger.
Yes, then
And we
that
held
too.
we held non-compensable.
then there would be a demonstration of personal
There
animosity.
was none, it was a stranger.
Then I think the question in that case, going back to the papers, is whether it was the question wasn't whether it rose out of the course of the employment, but whether it rose in the course of the employment. I think it was a different analytical question in that case. Now, when you look at the cases, though, that involve employees or family members of employees, that's when an analysis is employed to see if there are work-related differences. There can be no work-related differences in the context of a stranger. It's impossible. And so that's where I think the third department in its analysis strayed from this court's precedent. There can be no nexus, however slender, between the motivation for the assault and the employment if it's not another employee. It's not a litmus test that makes sense in the context of an assailant that's an unknown stranger. I think it's also important to point out that the law on this topic needs to be predictable and fair and consistent. And I see the light is on, if I may finish up.
Please conclude. Yep.
Yes, Your Honor. And that is, it's a trade-off. It's not always going to be the case that in the case of an unknown attack, there's going to be someone or an entity to place blame. And that those claimants, those people who are injured on the job, like the people in the Tops grocery store in Buffalo, that's a public place, and for which there was no liability in terms of the grocery store itself, should have an opportunity to be compensated. It is no different in this case, and I would close by saying that the board's finding as a matter of law was not arbitrary, and that the third department's decision should be reversed.
Thank you.
Thank you, Your Honors.
Good afternoon, Chief Judge and members of the court. My name is Arnold Chris, and seated to the right of me is Gabe Tausick, who is co-counsel on this matter. And if it may please the court, where to begin? I'm going to start with Rosen before any questions are addressed by the court, which I really look forward to. Rosen was a compensable case. Two employees had a fight over money that was loaned. One employee killed the other. What made it compensable, very simply, is that the work environment, the employer, condoned the loaning of money between employees.
But the court says there, I think, that an assault which arises in the course of employment is presumed to have arisen out of employment, absent evidence that it was motivated by personal animosity. And so I take it your argument is that you need some evidence that it is motivated by employment-related animus. Is that right?
Correct, Judge.
Okay, and-
Section 10.1 of the Workers' Compensation Law has two conjunctive elements connected by that one little word "and."
But I take it your argument is that to show arose out of, you have to show affirmative evidence of some employment-related animus. Is that a fair?
Yes, Judge,
Okay.
100% fair.
So if that's correct, then what work is the presumption itself doing? Because usually I think a presumption fills the space that affirmative evidence would otherwise establish.
When the legislature enacted with the governor, 21-1, the presumption is that if you're hurt at work, the only way to rebut that it did not come out of the course of employment is by substantial evidence, which the third department unanimously found that there was substantial evidence
Right,
rebutting. We
but
met
the
our burden.
statute instructs, I think, and Rosen says that there is a presumption, right? And so I'm just trying to grapple with how then we would conclude that affirmative evidence of an employment-related animus, where we don't know what the motivation was, how we would require that.
I think just based on, in this case, the substantial evidence, there's no relationship, no risk that Dr. Timperio was engaged in any patient or surgical activity. The flow from his work to the injury doesn't exist. This is a one-off situation that, as the Attorney General opened with, it's a tragic situation.
Counsel,
but
what
there's
is
no
the
connection.
what is the significance of that proof that you just listed? Because to me, it seems like that establishes an absence of personal animus, which was the rule that was crystallized in Rosen. So you must be arguing that it does something other than that.
Well, Judge, most respectfully, Rosen leaves out in the Court of Appeals two very critical words that are in all other cases. It's between individuals. It's between combatants. If you look at the third department's decision on Rosen, and if you look at all the other cases that are cited between employees where there is an assault, they're basically a co-employee nexus between two individuals, Judge Canatero, most respectfully, Canatero and Chris getting into a fistfight.
Never happened.
Never going to happen unless it's a wrong decision, and maybe I'll be a little upset. But the most important thing is is that in the workplace, it's all the cases, most respectfully, that we briefed, and I've read a number of them, it's two co-employees get into a fight. Whether it's compensable or not, you got to look at the total incident. If it's a fight between a co-employee and the girlfriend, and I believe there are cases like that, of another employee, it may not be compensable. But what the third department decided here unanimously, which to me is unique in these kind of cases to have that, is that there's no relationship. It's like an empty chair was shot, that Justin Timperio was sitting there, and in comes this individual. And the personal hostility, or the hostility that he had, the shooter, the assailant, was to him. It was arbitrary.
So would it be fair to say, however inartful this is about to be, that it was so random, so unconnected to the injured party, that it couldn't have arisen out of his employment?
Judge, it was so unconnected, unrelated to the injured party, who was a medical resident who signed on to be a doctor on a Hippocratic oath to do no harm, was wound up getting harm.
Counsel, let's say it wasn't a doctor here. Let's say it was somebody working in the hospital for a contractor, or, for a subcontractor, and same situation, same randomness, but they don't have somebody like Bronx-Lebanon Hospital to sue. Let's say it's another situation where the employee does, that employee is not entitled to workers' comp benefits under these situations.
Judge, I'm certain I just didn't understand the question. I
Let's say,
apologize.
in this case, you want to sue the hospital, right? That's your goal. And you don't want workers' comp benefits because you have this other pocket that you can sue. But let's say it's a situation where somebody gets shot or somebody gets injured in one of these random attacks in a business that does not have that type of resource. And now they're not entitled to workers' compensation, right?
If I understand your question, if there was an individual who comes into a bar, for example, and he pulls a gun and
Let's say it's a guy who's working in a bodega, and somebody comes in and
anything,
shoots
a
him.
bodega, anything.
Right.
The bottom line really is that the way the legislature is set up, based on the United States Constitution going back to the Wainwright Commission in 16, before I was born, the key thing really is that if an individual goes in, an assailant, does a shooting, shoots the bodega guy who's behind the counter, the presumption applies that he was hurt at work. And then it falls on the basis to the employer, generally, who doesn't want the claim for whatever reason, to present substantial evidence to rebut it. And basically, in most of the cases that
So the difference in here is you don't want the benefits. That's the difference here, is only the posture of this case, that you don't want workers' compensation benefits?
You mean on behalf of Justin Timperio? No. Judge, I think, to be intellectually honest, I don't believe, as an advocate standing before the Court of Appeals, that the facts in this case make out a workers' compensation case. And of course, my argument is we don't want it because we're going to have perhaps another matter in another courtroom that has nothing to do with workers' comp.
Well, you already do have that, right? That's pending in the Southern District, I thought, but stayed. No?
I'm sorry, Judge.
I thought you already had a separate action pending, no?
We do, and Judge
Gardefee, I
Gardefee,
think, yeah.
excuse me, in the Southern District, on a motion to dismiss a lawsuit, who didn't even talk about the presumption, dismissed the motion of Bronx-Lebanon and dismissed a summary judgment motion that they made, finding that 10.1, that although Timperio was hurt at work, it wasn't connected to his job. So we went in the federal court, which we know is not binding.
So there's a case.
We know it, but it's a good guidance.
There's a case of ours that I'm having a lot of trouble figuring out how it is any different from your case, and I think you're going to have to get around it. It's a case called Katz v. Cadence from 1922. Are you familiar with it?
I'm sorry, Judge. I'm losing just a little bit.
Sure. Are you familiar with one of our precedents from 1922 called Katz v. Cadence?
Yes, Judge.
Okay, so-
Again, I've read Katz v.
Yeah,
Cadence.
so we held there that the injury was compensable. And what happened there, just to refresh your recollection, is that there was a man who was a cheese proprietor. He had a chauffeur. The chauffeur was delivering cheese for his business. After the cheese delivery, the chauffeur was getting back into his car, and he was being chased by an insane man who was stabbing everybody he could who got in his way. He stabbed the man, the chauffeur. We held that's compensable. How is that different from this case?
Well, in Katz, if I remember correctly, he was doing a job
Yep.
for an employer,
Same as Timperio.
and I would bet you, and again, I'm going to get my C- on Katz in a moment, I would bet you that the employer probably did not offer any substantial evidence, and it turned out to be compensable. A lot of the cases that have been before this court and the Third Department, the employer just surrenders by doing nothing in terms of substantial
So
evidence.
what evidence would you have wanted the employer there to tender?
I'm sorry, Judge.
What evidence would you have wanted the employer there to tender?
Good question. In Katz and all similar cases, what the employer should have done, and I'm not the attorney for the employer, I would have investigated the circumstances. I would have seen if they're to defeat. as the employer-
You have just pretty much as you have here, an insane man randomly attacking people, right? What kind of evidence in that circumstance would you want an employer to put forward to say this should not be compensable?
Probably nothing. He probably would be thrilled that it was be a random, so he wouldn't have to have his insurance company pay benefits. My sense really is that it's hard on a random attack. This wasn't a random attack. Katz, I mean, it was just not a random attack. There was a lot of things going on, and an individual was no different than the other individuals who were stabbed or shot or killed at that, or injured at that point in time. I think I would have to look at Katz really very carefully and trying to sit as a judge, weigh whether or not it's compensable or not. I don't see the evidence in the Katz case
So
that would endorse to the benefit of compensability.
to be clear, then,
Yes,
I'm
Judge.
sorry, is your position, and it was similar to the question I asked the other side, is your position that, let's just use the word shooter here, the shooter had to plan or intend, or that was the goal, to shoot Mr. Timperio, or Dr. Timperio specifically?
I would have to speculate. I have no idea what was in this deranged individual's mind.
I'm not asking you to speculate, I'm asking you about what should be the law. Your understanding of the law.
My understanding of the law is, I think that you spoke on it, and I'm not going to go to my notes, I don't have the patience to do it, but basically, taking section 10.1,
Okay.
which the legislature mandated in terms of conjunctive elements for a case to be compensable, the mere fact that the shooter showed up as the assailant, and he just randomly shot in a room and hit an individual who had no idea
But that's
what
what
this
I'm
was
saying. Your
about.
position is that if it's random, it's not that, again, using this example of the shooter comes in and they are looking to shoot that particular person, as opposed to they're just spraying the room with bullets,
Right.
right? Is that what you're saying is the way we should understand the law? That's your view of the law?
What I'm saying is that
He had to come in to shoot Timperio.
when he came in to shoot whoever it was, he didn't know Timperio, Timperio didn't know him. His state of mind, the assailant pulled that trigger.
Yeah.
At that point in time, when that bullet left that chamber and entered Timperio, I would only think, God forbid, to be faced with an AR-15 shooting, that the oh my God moment set in like, why is he doing this to me? I don't know this guy. I've never seen him. I've never heard of him. I have no idea. I never got him angry at me. I have nothing.
Ergo, the random shooter. But again, is your rule that the shooter, I'm not asking you whether or not that's the case here, I just want to know, is your rule that the shooter should intend to actually injure the person who is claiming the workers' comp benefits? As opposed to, I just want to shoot up this floor of the hospital.
There is no difference in him shooting Timperio and shooting also, which is in the record, a patient who was
Yes,
there.
yes.
They all were the same targets at that point. The one suggestion, if I could be so bold to make it, Judge, in listening to your question, a random shooting, I mean, this is going on across the country. This is outrageous. And I don't want to get emotional in the Court of Appeals, but the bottom line is, Justin Timperio was shot in 2017. Just think about how many AR-15 shootings across the country.
But your view, counsel, I think, is that, and this I think ties to the question Judge Garcia asked you, that whenever you have a shooting in a workplace where the employer does not have resources, that employee is nonetheless not entitled to any workers' compensation
agree with you.
benefits. Well, then in what circumstance would an employee be entitled but is not entitled here?
The employee has a due process right to file a claim when he's
Sure.
shot with a workers'
But we're
compensation.
talking about whether the employee is in fact entitled to compensation, right?
I think it depends on the incident. I mean, it's so hard to basically parse just getting shot without knowing what happened in the surrounding environment. I think basically.
Let's say it's exactly the same facts here, except you have an insolvent employer. Exactly the same facts, but you have an insolvent employer.
What do you mean insolvent?
You have no recourse against the employer, no insurance, no resources.
I don't think that's relevant, Judge. Most respectfully, I'm going to disagree with you.
You may not, but could you answer my question? So, same situation you have here, you have an insolvent employer, no insurance, that person now goes in to file a claim, they are not entitled to workers' compensation.
Okay, so
And what would the policy reason consistent with why we have workers' compensation be that we would want that?
because what you're going to is the exclusivity provision of giving workers' compensation to an individual who is hurt in the workplace. To get there, insolvent or not, the path to workers' compensation is through the conjunctive.
Okay, so your answer is that person would not get benefits. That's the answer to that question.
Depending on the facts, correct.
Oh, and these
And
facts.
there is a possibility he would not, that's true. In this case, there is no way that I would be able, as an advocate, to stand up and basically say with all honesty, and I'll pride myself on my integrity, that this is a workers' compensation case.
Thank you, counsel.
I can't do that.
Thank you. The red light's on.
Am I done?
Yes, you're done.
Judge, thank you very much.
Counsel, can I ask you what you do about Lemon and Malacarne?
Yes, so those are both cases analyzing the in the course of employment prong.
Lemon is the commute, right?
That's right.
And Malacarne?
Malacarne is about a parking valet
Right.
who got into.
He left work
He
in
left
Malacarne.
work, yeah.
He was out.
Yeah.
Yeah,
So those are both.
So these are we in the course of when we're on the way to or leaving?
Correct, correct. So those are not relevant here, and that was one of the points I wanted to make. Second, just to pick up on where Judge Garcia was heading, I mean, I think that is the clear implication of my adversary's argument, which is that not only does it leave employees without a remedy if their employers are insolvent, but it's very likely the case in many cases that the employee will not even have a valid cause of action against the employer in the first place. So there might be no reason to sue, no basis to sue and no basis to get recovery against an insolvent employer. And finally, just briefly, again, to respond to Judge Halligan's question earlier, which is that the third department's rule does put the burden on the claimant to come forward with affirmative evidence that it was employment related. And that's exactly the thing that's wrong with it, which is that it basically vitiates the effect of the presumption. What work is the presumption doing if you have to affirmatively come forward with evidence that it was employment related? So the primary question here is, was there evidence of personal animosity sufficient to rebut the presumption? If no, the presumption has not been rebutted and the claimant is entitled to benefits. The third department here asked an entirely different question. Was there evidence of an employment-related motivation, and found the absence of that evidence sufficient to overcome the presumption, which was rebutting a presumption with a negative, essentially. So for all those reasons, we ask the court reverse the third department's order. Thank you very much.
Thank you.